I will do anything, anything.
Sir, that is the order of this court. After your 10 days, you certainly have lots of time that you can obtain employment.
Right from the start, you can feel the tension in this courtroom. The judge isn't here for excuses. She's about to call out a defendant more focused on his tether than his terrible choices. Buckle up. This one gets heated fast.
Instead of utilizing your opportunity to express any remorse, you just want to know if you're getting your tether off. That's what I just heard.
That's what my tether officer told me.
You're missing my entire point, sir. You're missing my entire point.
No, Your Honor, Neil Boyd here on behalf of James King. Please state your name, sir.
James King.
All right, good morning. Thank you very much for being very loud. And the court, sir, as to the arraignment in this matter.
Sorry.
I'm sorry.
This is a sentencing hearing.
No, I'm sorry, sentencing. I'm so very sorry. Change the date time scheduled for sentencing on your client's plea to an amended charge of operating while intoxicated. First offense, driving while license suspended and open intoxicants. And the operating while intoxicated second offense was dismissed by way of resolution between counsel. Counsel, do you have an opportunity to review the report and recommendation with your client?
On over it. King indicates that there is an update, a negative update. His full-time employment at Quanta was recently terminated. Is that correct?
It wasn't terminated at Quanta. I had gotten a new job that I was waiting for at Steel Tool Engineering. And when they found out I had a tether, they fired me. And Quanta won't take me back, and I'm having a hard time finding a job. I've applied at multiple places. I'm waiting for Roush and the Oakwood Group to call me back, but no one's calling me back.
Okay.
And a roofing company I also applied for, but they go out of state, so I don't know how that would work with everything I'm going through right now.
Okay.
So although currently unemployed, it's clear that he's attempting to remedy that as soon as possible. However, I think everything else in the report is accurate, sir?
Yes, sir.
Yes. So the conditions do seem in line with circumstances here. He would prefer, obviously, for the court to consider not assessing the jail at this time. Let him complete his job search, get his feet back under him, and he's committed to sobriety going forward. Anything else you want to add?
My tether officer told me I might be able to get this off at my sentencing. Is that going to happen or no?
Sir, are you for real?
That's fine.
No, just one moment. You're here for sentencing on a second offense OWI, right? Well, actually, it's a first, but it's technically your second. And so instead of utilizing your opportunity to express any remorse or anything like that, you just want to know if you're getting your tether off. That's what I just heard.
That's what my tether officer told me.
You're missing my entire point, sir. You're missing my entire point. It was your opportunity to express your remorse to the court, if you have any. And instead of doing that and acknowledging the poor choice you made on August 8th, your first concern was whether or not you were getting your tether off. That's your concern. Not the amount of risk that you put forth to the community or yourself or otherwise. Tell me what's going on with your 3 warrants.
I was working on paying them off and I got fired from my job because of the tether. I was trying to save up money and I got fired, and I had the money I had to spend towards bills.
So that's a, let's see, you failed to appear for a review hearing in the 23rd District Court, October 28th to 24. You've had a year to take care of that and you have not. You also have a warrant out of the 23rd for double parking that you didn't pay, which is $400. And then also from the same date, a warrant was issued for, because you didn't show up for paying your stop sign ticket, which occurred in 21, by the way. Let's be very clear on that. That occurred in 21. So you have those matters. And sir, let's just also be very clear that you just had the tether affixed when you were here for arraignment September 18th. So you've had a lot of time that you could have taken care of your warrants and you have chosen not to do so. You also have a prior operating while impaired out of Van Buren in April of 22. And then you also have a fail to report from February of 25 in this court. And sir, how did you get here today?
I got dropped off.
Who dropped you off? How were you getting back and forth to work?
Co-worker who was vanished.
And do you have any keys in your pocket right now?
House keys.
No, there's, what else? What is that?
It's a bunch of random keys. There's no car keys though.
Oh, okay. If you're to test right now, sir, what's in your system?
Nothing.
So, sir, not only do you already know what your level is when you're over a .08 and you're not legally able to drive, right? You are more than twice that limit. You're more than twice that limit. And not only that, you're not even legally allowed to drive. And yet you were driving that day. Yet again.
My license had just got suspended at midnight.
But you had noticed it was going to be suspended.
I didn't notice it was the 8th. I think that was the date.
You received notice that your license was going to be suspended, correct?
Yes.
Right. So that's on you, sir, to know what date of the week it is. What date of the month, what day of the week. That's your responsibility.
Yes.
This is the moment every viewer feels desperation.
Of the matter,
he's pleading for a chance, saying he's sober, trying to turn things around, but the judge's duty isn't emotion, it's law and order. The court must protect the community first. It's harsh, but that's the balance of justice versus crime.
After hearing from counsel, hearing from Mr. King, reviewing the report, the recommendation, the court will find that there is reasonable grounds to depart from MCL 769.5. The court's also going to find the following sentence being the best interest of justice to be reasonable and proportionate to the seriousness of the matter, taking into account the circumstances surrounding Mr. King and the legislative guidelines. The court's going to order 18 months probation. You're eligible for early discharge. I'll go over that in just a few moments. You are not to violate any criminal law of any unit of government. You're not to leave the state without the consent of this court. You are to report truthfully to your probation officer as often as your probation officer may require, in person, in writing, or virtually. You're to notify your probation officer immediately of any change in address or employment status. You not use any alcohol or drugs unless prescribed to be subjected to random testing. The rehabilitative goal for that condition is so the court can monitor your progress in maintaining abstinence and sobriety. You are to enroll and participate in outpatient substance use counseling. The rehabilitative goal for that condition is so that you can have assistance in providing coping mechanisms to maintain sobriety and hopefully prevent this matter from happening again. You are to participate in the Armed Weekend Program. The rehabilitative goal for that condition, sir, is so that you can further educate yourself regarding drug and alcohol use and learn trust and coping skills so that hopefully this will assist you in preventing this matter from happening again. As to, then you also have the MAD Victim Impact Panel that you have to attend. The rehabilitative goal for that condition is to help you further educate yourself regarding the dangers of driving while under the influence and the circumstances, the consequences of such behavior. The court's going to also have you participate in fan meetings once per month. The rehabilitative goal for that condition, sir, is to help you in maintaining your sobriety as well as receive some recovery resources. You're not to operate a motor vehicle. The court's going to order 10 days on the court workforce. The rehabilitative goal for that condition is to help you further develop life and work skills and give back to the community. The court's going to order mandatory jail for any probation violation. And the court's also going to order 10 days jail. All that is to count 1 only. Counts 3 and 4 will be fines and costs only. As to, you have any questions regarding those conditions?
I'm going to jail.
Yes, please keep your hands off your pockets. For 10 days, you're going to jail, sir.
Please. And I've done no alcohol, no drugs. Please, I'm trying to get a job.
So I understand that.
Please.
But my responsibility is not whether or not you get employment. My responsibility is to make sure the community is safe.
Please.
This is your second offense. And not only is it your second offense, you weren't even legally able to drive that day. And you were at a .178. You have a prior just a few years ago, sir.
Please, please. I will do anything. Anything.
Sir, that is the order of this court. After your 10 days, you certainly have lots of time that you can obtain employment. Because at that point, your tether will be removed. And you won't have to worry about having a tether be a reason why you don't have employment. As to your fines and costs, the court's going to order a $500 fine as to count 1, $100 screening assessment fee, $900 supervision oversight fee, that's $50 a month at 18 months. Since you're eligible for early discharge, up to half of that could be waived. $300 for the cost of prosecution, crime victim assessment fee of $75, justice system assessment fee of $50. Workforce of $400, that's 10 days at $40 a day. Totals $2,325. As to count 3, the court's going to order
And there it is. 10 days in jail, 18 months probation, and over $3,000 in fines. A harsh but measured outcome. The real takeaway? Every decision has a ripple effect. One drink, one drive, one missed court date can change everything. What do you think? Fair justice or too far? Comment below.
a $300 fine. I'm not assessing a screening or oversight fee. $200 cost of prosecution. Crime victim assessment fee of $75. Justice system assessment fee of $50 for a total of $625. As to the open alcohol, count 4, $100 fine, $100 cost of prosecution, crime victim assessment fee of $75, justice system assessment fee of $50 for a total of $325. For a total between all 3 matters of $3,275. You did post a bond, so we will apply the bond, and then you'll have to set up your payment plan through probation upon employment. So I can appreciate you haven't used any alcohol since you at least have been arraigned. Okay, so that's good. However, this court has a responsibility. You have prior charges. You have a first offense on the 22nd. You have 3 warrants, and now you have this matter. So that is the order of the court.
Will I be able to call my mom so she can come grab some of my things for me?
You should be able to. I'm not sure they should. You should be able to make a phone call back there. All right, you're going to be going out this door today. Good luck to you, sir.